Good morning, ladies and gentlemen. This is Greg Ross with the Landegger Verano Law Group, and welcoming you all to our presentation today, which is Compensating the Non-Exempt Employee in California, and all of the pitfalls and potholes and landmines that entails. Our presenter this morning will be our partner in the firm, Roxana Verano. And just a couple of notes for you as attendees. This is meant to be an interactive process, meaning that any and all of you can type in questions during the presentation, and we will do our very best to hold out maybe 10 minutes at the end of the presentation to respond to those questions. And just so you know, if you have questions that are unanswered, we will certainly get back to you. Also, if any of you are looking to have HRC credit or SHRM credit for this presentation, please send me just a brief note at the end of the presentation, and we will email that certificate to you for 1 hour of CEU credits. At this point, I would like to introduce and welcome Roxana Verano, and thank you so much, Roxana. You're on live and online.
Thank you, Greg, and good morning, everybody. Thanks for joining us today. So as Greg just stated, we're going to talk about compensating the non-exempt employee. So this is going to be a very presentation directly to address the hourly employee. We're not going to talk about salary employees or exempt employees, but it's going to be primarily for those hourly employees. Before we start, let me just say that if you have any salary employees, you should make sure that they're properly classified. And if you have any doubt as to whether or not an employee is properly classified as a salary employee, then I will go with a safe route and classify the person as a hourly employee. So let's start by covering some basic unique issues concerning wage and hour claims that I think are important to understand when we have hourly employees. First of all, every employer must remember that the burden is on the employer to maintain proper timekeeping records, and that includes timesheets and payroll stubs. The law places the burden on the employer. So if somebody were to file a claim against the employer, it is the employer who has a duty to be able to show how many hours that employee worked and how much money that employee was compensated. Now, the reason why we do these presentations is because if there's non-compliance with the strict laws under the labor code, the employer can be subjected to significant legal liability. For example, if an employee is not paid the proper minimum wage, that employer will be liable for the payment of the minimum wage plus liquidated damages, which is the same amount of the minimum wage that was not paid. There's also can be significant liability for not paying the proper overtime, and also for not providing employees with a state-compliant meal and rest periods. Once there's any violations of the labor code, the reason why these claims become so expensive to litigate or to settle is because there are many penalties that are related to the failure to properly pay an hourly employee. And of course, there's always the risk of a PAGA claim, a class action lawsuit, both of them being representative claims that allows the employee to recover both statutory and civil damages. And that can be a very expensive proposition for an employer. So in addition to that, the labor code laws provide for the recovery of attorney fees to the employee, not to the employer, only to the employee, which means, again, that any violation of these strict rules can subject the employer to significant liability under the law. So let's cover some of the basic rules concerning hourly employees or non-exempt employees. California law requires that employees be paid for all hours worked. It's a very straightforward, very simple requirement, but they do expect employees to get paid for every single minute that they have worked. Now, the wage orders provide us a definition of what it means for an employee to work, and generally it has to do with control. So anytime the employer has control over the employee's time, that person is considered to be working, regardless of whether the employee was asked, required, requested to work. If the employer has control of the time and the employee is performing work, then that employee must be compensated for that time. So a different way of stating this is, even if an employee were to show up at the workplace and he's not expected to work, or he has not been asked to work, but the employee engages in work, then the employer has the responsibility to compensate for that time. Just remember that California requires that employees be compensated for all hours worked. One of the many issues that I see with our clients is travel pay. Very often employers do not understand that employees must be compensated for any time that they spend traveling other than the what we call commute time. So the time in which the employee goes from their home to the first location of work, or the time that the employee spends going back home from the last location of work, is not compensable. Any other travel time in between is compensable and must be compensated. If an employee is required to report to a central location, let's say a warehouse or a specific office, and then the employer is required to travel to a location to work, then that period of time will also be considered to be travel time, and it should be compensated. Now, the law does allow for an employer to pay a different rate of pay for travel time. It has to be at least the minimum wage. But if an employee is compensated at a higher rate, a higher hourly rate, the employer can compensate the employee at the minimum wage rate for the travel time. Reporting time. There's another area where some employers seem to have some issues, and I thought it was important to include in our presentation. An employee is entitled to be paid if the employee shows up for a scheduled shift but is not permitted to work at all, or if the employee shows up to work but works less than half their scheduled shift. So in those incidents, the employer is required to pay the employee the regular pay rate for at least half of the employee's usual or scheduled day's work, with a minimum of 2 hours of pay and a maximum of 4 hours of pay. If an employee is required to report to work for a second time during the same workday, then the employer must pay the employee for a minimum of 2 hours, regardless of how many hours the employee actually works. Now, there are some exemptions here, and that is there's no requirement to pay the employee if the employer's operations cannot begin or continue due to a threat to employees or property, or authorities recommend that the employer not begin or cease operations, or an act of God. These are very limited exceptions. So if you are in a situation where you're requiring the employee to report to work, but you cannot provide them with the hours of work that they were expecting to work, then you're going to have to pay them a reporting time. On-call standby. I definitely see a lot of confusion with on-call and standby. Here we go back to the concept of control. Okay, so it's an easier way to understand it is to look at it from two different perspectives. Is it a controlled standby? In that situation, if an employee is required to remain on call on the employer's premises or so close to the employer's premises that the employee cannot use his time effectively for his own purposes, then that time is considered hours worked, and it will be considered for overtime calculations. Again, this controlled standby can be compensated at a different rate of pay, as long as it's minimum wage. Uncontrolled standby means that an employee is not required to remain on the premises, but is merely required to leave word about where he may be reached or is given a beeper, that's the old-fashioned beeper, or a cell phone where the employee can be reached. And if the employee can actually use the time for his own purposes, then that will not be considered hours worked. Another way of looking at this is if the employee has the ability to reject the work. So this is a situation where an employer will call an employee and say, can you work today, later today at 2 o'clock in the afternoon? If the employee has the ability to reject the work, then that is uncontrolled standby and is not considered hours worked and does not need to be compensated. Now, there's some employers that have the practice of paying either a flat fee or even an hourly rate that is less than the minimum wage for somebody to be on uncontrolled standby, meaning that they are on call, but the employee has the ability to use this time in any way, manner they want to, and they're not restricted in time. That is allowed under the law. You can pay them any amount, a flat fee, an hourly rate, even less than minimum wage, as long as the standby or the on-call is uncontrolled. Again, meaning that the employee has the ability to reject the work or has the ability to use the time for his own purposes and is not compelled to return. So again, when we look at standby, we need to look at the amount of control that the employer has over the employee's time. If the employee is required to stay within, let's say, a geographical area of the employer's premises, then that will most likely be controlled standby and should be compensated at least at the minimum wage rate. Meetings, lectures, trainings. Again, we're dealing with the issue of control. If an employer requires an employee to attend a seminar, a meeting, a class, any kind of a meeting, then the employer must pay for that time because that is considered hours worked. If the employee chooses to take a class, attend a meeting, a seminar that is outside the regular working hours, where attendance is voluntary, it's not mandatory, and the meeting, the lecture, or the training is not directly related to the employee's job, meaning there's no benefit for the employer, and the employee is not performing any productive work while at the meeting, lecture, or training, then the employer has no obligation to compensate for that time. The easiest way to remember this requirement is if you are requiring the employee to attend, you need to pay that employee for the time they're attending the lecture, the meeting, or the class. If the employer is receiving some form of benefit for the employee taking the class, the meeting, or the lecture, then there's a possibility the employer may have to pay for that time as well. Split shift premium. Now, this will apply only to in very few incidents, and this is why. The wage orders require an employer to pay a premium of 1 hour of pay at the minimum wage rate to an employee who works a split shift in a workday. What is a split shift? A split shift is when an employee has a break in the day of work that is longer than an hour. Okay, so this is the actual definition is a work schedule interrupted by an unpaid non-working period other than a rest or meal period, and like I said, that generally means longer than an hour. We see the situations in restaurants. Sometimes employees are required to work in the morning for a couple hours, and they're expected to return in the evening for dinner time and work additional number of hours. So those are the situations where there's a big gap between two shifts that take place in the same workday. However, the employer is only required to pay a split shift, meaning that additional hour of premium pay, only if the difference between an employee's total pay at his regular rate for the entire day and the minimum wage multiplied by the number of hours worked in the day is less than the minimum wage. So this generally applies only when an employee is earning minimum wage. or a small amount over minimum wage. So I have an example here. If an employee works 8 hours at $13 an hour, that employee is going to be compensated about $104 for the day. Now, in LA County, in LA City, the minimum wage right now is $12 an hour. So if we take the 8 hours times 12, that means that the employee at the minimum wage rate would have earned 96. So now if we take the difference of those two numbers, 104 minus 96, that means that the employee has earned an additional 8 hours over the minimum wage requirement, right? Then the employee must receive a split shift of $4 because that's the difference between the minimum wage and the additional 8 hours that the employee was compensated. Now, if the employee earns $14 an hour, then he will be compensated $112 for the day, and the difference between $112 and the 96 that the employee will be entitled under the minimum wage is $16, which is more than the minimum wage. In that scenario, the second scenario, the employee is not entitled to be paid the premium 1 hour for a split shift. So you need to first look at the difference between the employee's total pay at his regular rate and the compensation based on the minimum wage. And you only need to pay the split shift premium if that difference is less than the actual minimum wage. And you only need to pay the difference between the difference between the additional the minimum wage and the additional money that would have to be paid to meet that requirement of the minimum wage. It can get a little complicated, but like I said, this will only apply if an employee is earning minimum wage or a small amount over minimum wage. But you do need to do the calculation to see whether that person is entitled to the minimum, to the split shift premium. Overtime rules. Okay, this is a common mistake that employers make with overtime calculations is that they believe that the overtime rate, the time and a half overtime rate, is only based on the employee's the employee's hourly rate or stated hourly rate. We hire somebody, we say we're going to pay you $13 an hour. And then people assume that that means that the overtime rate is time and a half of $13 an hour. However, the regular rate has a very specific definition under the labor code. Okay? Overtime must be computed not on the hourly rate stated to the employee, but on the employee's regular rate. And the regular rate will include not only the hourly earning that we have promised the employee, but any other compensation that is given to the employee, whether it is in the forms of commissions, whether it is a bonus, as long as it's a non-discretionary bonus, meaning a bonus that is based on performance or production. All that compensation needs to be included when we determine what the employee's regular rate is. So again, many employers believe that regular rate necessarily equals the hourly rate that the employee gets paid, and that is not the case. We need to include all the compensation that the employee receives as part of the work that he or she is performing. Now, we do not need to include vacation pay or PTO pay or sick leave or holiday pay. Okay? But what's key about this, and in another area where I see employers get into trouble, is that, first of all, they need to determine what their work week is. We cannot calculate overtime if we do not know what the work week is. Now, the work week can be any 7 consecutive 24-hour period that the employer wants to choose. It can be Wednesday through Tuesday. It can be Friday through Thursday. And if the employer does not assign a specific work week, then the law would assume that it will be Monday through Sunday. But there has to be one work week that is established by the employer. Okay? Otherwise, we cannot calculate overtime because overtime is calculated based on the work week. Okay, I see employers that have, let's say, a 15-day payroll period. Payroll period begins on the 1st through the 15th, and the second payroll period begins on the 16th through the end of the month. And very often, they don't understand that you cannot base the overtime based on the payroll period. You need to calculate the overtime based on the work week. So regardless of what form or what type of payroll period you have, you still need to establish your work week. The same way that you need to establish a workday. A workday is any consecutive 24-hour period beginning at the same time each calendar day. Can be midnight to midnight, but an employer can also have a workday that starts at 2 p.m. and to 1 p.m. of the next day. Again, it needs to be established ahead of time, and it cannot be changed just to avoid paying overtime. It can be changed, but it needs to be changed with the intention of being permanent moving forward. And the reason that we need to establish a workday is because under California law, an employee is entitled to overtime pay when they work more than 8 hours in one day. Now, I have mentioned before that an employer is allowed to compensate an employee for travel time at a different hourly rate. Same thing with standby time. If the employee is earning more than minimum wage, the standby time can be compensated. Even controlled standby time can be compensated at the minimum wage. The problem is that when employees are being paid two different hourly rates for different type of work, if that employee works overtime, now we need to come up first with the average of those two hourly rates in order to determine what is the regular rate of pay. Okay, and the way we do that is we take the employee's total straight time wages for the work week at all applicable rates, and we divide that by the total hours worked for all the jobs that the employee performed. So you see an example there. If somebody works 32 hours at $20 an hour and they work 10 hours at $15 an hour, the total compensation for the week is going to be $790. Then we divide that by the total number of hours worked, 42, and our regular rate is going to be $18.80 an hour. That is the rate that we're going to use to calculate overtime. Now remember that if this employee is also receiving bonuses or commissions or some other type of compensation, now we need to also take that in consideration when we determine the regular rate of pay. So just quickly, California requires overtime pay in 5 different situations. Any hours beyond 8 hours in a workday, any hours beyond 40 hours in a week, the first 8 hours of work on the 7th consecutive day in a work week. That means that if an employee works 7 consecutive days in one work week, the first 8 hours of that 7th day is going to be all overtime. Now, don't confuse that with 7 consecutive days across different work weeks. Again, this is why it's important to have an established work week. The 7 consecutive day has to take place within the same work week in order for this to apply. Any hours over 12 hours of work in a day will be double time. And any hours beyond 8 hours on the 7th consecutive day within a work week will also be paid at a double time rate. Limited exceptions to overtime rules, and I do mean they are very limited. There's not that many situations that allows for the non-payment of overtime, and one of them is the make-up time provisions. I think there's many employers who do not take advantage of this, or sometimes they do it without the proper documentation, and it's key that the employer have the proper documentation. An employee is allowed to work up to 11 hours in a day without overtime payment if the employee is making up the time that they lost within the same work week. Again, we cannot go beyond the same work week. That means that if today I'm supposed to work 8 hours, but I tell my employer that I need to go to a doctor's appointment or I need to go to an event, and I want to work I want to make up 3 hours tomorrow. That means that today I'm only going to work 6 hours. No, I'm going to only work 5 hours or whatever hours I want to work, and I'm going to make up the difference on the following day. The law allows me to do that. That means that tomorrow I can work up to 11 hours without having to be paid overtime. However, there must be something in writing that shows that the employee is the one who made the request. The employer cannot make an employee make up time on a different day. So the employer cannot say, go home today because we don't have enough work for you. Tomorrow you can work 11 hours, but we're not going to pay you the overtime. It has to be at the request of the employee. The only way that we can show that it was at the request of the employee is if we have a writing. So it should be in writing and should be done every time the employee requests to make up time in a work week. So it's not a good idea just to have like an agreement on the file. It should be a form that is used every time the employee requests to make up time. But I want to emphasize that the make-up time has to take place within the same work week. We cannot make up the time next week. Okay, quickly about meal periods. We continue to see quite a few number of PAGA claims and class action claims because of meal periods. The only way to avoid having a claim for meal periods is for the employer to make sure that employees are taking a state-compliant meal period. So what does that mean? That means that the employee must receive 30 minutes duty-free. That means they're not required to do any work. Okay? If the employee works more than 5 hours in a workday. It also means that the employee has to be allowed to leave the premises. The employer cannot require the employee to stay on the premises. The employee must be able to take 30 minutes with no work, and they have to be able to leave the premises. Now, if the employee works less than 5 hours, then there's no requirement for a meal period. Okay? And as you can see here, it makes it very clear, this comes straight from the Brinker case, the employer should relieve employees of all duties, relinquish control over their activities, and not impede or discourage the ability to take the meal period. Okay? Now, this is where many people make a mistake. That 30-minute meal period must start before the end of the 5th hour. That means that if somebody starts to work at 8 o'clock, that meal period needs to start before 1 o'clock. It can be 12:55, it can be 12:50, 12:45, but it needs to start before 1 o'clock. If the meal period starts at 12:02, that is a violation of the law, even if it's for a minute or a couple minutes. Okay? Now, if the employee works more than 10 hours in a workday, then that employee is also entitled to take a second 30-minute meal period. Okay? Now, if the employee works more than 10 hours but less than 12 hours, then the employee has the ability to waive their second meal period, provided that they have taken the first one. They cannot waive both of you, only the second one. In order to do this, you need to have a waiver form in your file. It doesn't need to be signed every time that they're going to waive their second meal period. This is the type of waiver that you can have the employee execute, and you put it in the file, and it's good for in any time that the employee works more than 10 but less than 12 hours in a day. Now, if the employee works no more than 6 hours, the employee again can waive their meal period. Okay? So again, this is something that you need to have a writing in order to show mutual consent. This is another waiver that you can keep in your file. It doesn't need to be signed every time they're going to waive their meal period. You can have a standing waiver signed in your personal file. The key here is that the employee cannot work more than 6 hours. Okay? So if the employee is signing this waiver because he usually works a 6-hour shift, but that employee, for whatever reason, goes beyond the 6 hours, 6 hours and 2 minutes, now the waiver is no longer valid and there's a technical violation of the labor code. So I generally recommend that if you're going to rely heavily on a 6-hour waiver, meal waiver, that you schedule your employees to work 5.5 hours or 5 hours and 45 minutes. That way, if for whatever reason they're late, you're not in violation of the law. I also recommend that when you schedule lunch periods, do not wait until right before the end of the 5th hour. Schedule lunch periods after 4.5 hours. That way, there's half an hour buffer there that if their employee is late going on their meal period, there's no violation of the law. Now, if the employer notices that there's a violation, a technical violation of the meal period requirement, let's say somebody was late, so the person was not able to leave work by the 6th hour, or somebody takes a 5-minute late lunch period, any of those technical violations can be corrected by the employer itself. The law allows for the employer to pay an additional hour of pay for that day where the employee was not able to take a compliant meal period. So it's like a self-correcting penalty that the employer can use in order to fix a violation that has taken place. Now, something to remember about this, though. Generally, this is, I tell my clients to pay the 1-hour penalty. We call it a premium pay. If the reason that the employee was not able to take their meal period was because of work. Like I said before, let's say the person that is supposed to relieve this employee is running late. Therefore, the employee, instead of working 6 hours, has to work 6 hours and 10 minutes or 15 minutes. Then we pay the additional premium pay and we correct the technical violation. If the employee is taking non-compliant meal periods, meaning late or short meal periods, so they're not a full 30 minutes, or they just skip their meal period altogether, but the reason that the employee did not take a compliant meal period was not related to work, but it was because the employee voluntarily chose to not to take a meal period or to take a non-compliant meal period. In that situation, there's no obligation on the employer to pay the additional hour of pay. There's a very narrow provision that applies to what we call the on-duty meal period. Okay, the labor code allows for an employer to have an employee sign an on-duty meal period where the employee agrees to work through his meal period. However, it's a very narrow exception. It only applies if the nature of the work prevents the employee from being relieved of all duty. And this is a very strict requirement. The law really expects employers to do everything they can to be able to relieve the employee to take a 30-minute lunch period. But if the nature of the work doesn't allow for that, then the employee can agree to get paid for that hour and take their meal period while they're work. Okay? There has to be something in writing. The writing has to state that the employee may revoke it at any time. Obviously, the employee is going to get paid for the meal period because they're working through the meal period, and the employee is permitted to eat his meal while he's working. I will highly recommend that before you use this on-duty meal period, that you consult with legal counsel because it's a very narrow exception. Breaks, rest periods. Employees must receive a 10-minute duty-free rest period for every 4 hours of work or major fraction thereof. Major fraction thereof means 2 hours. The employer is required to permit and authorize an employee to take a rest period. And those are the terms that are used by the labor code: permit and authorize. Rest periods and meal periods cannot be pulled together. The employee does not have the ability under the law to say, can I combine my 2 10-minute periods and my 30-minute lunch period and take a longer period of time off? The law does not allow for that, even if the employee wants to do it, even if the employee signs a document, that is not allowed under the law. You are required to have your employees clock out and back in for meal periods, but not for rest periods. Okay? There's no such requirement. I generally recommend that an employer do not ask employees to sign clock out and back in from rest periods, because the amount of time is so short that makes it difficult to manage and to actually keep track of the rest period. And what I see happening very often when employers try to do that then we have incomplete records that it, rather than help the employer, it hurts the employer. Okay, so remember, you require your employees to clock out and back in for meal periods, but not for rest periods. Payroll records, it's like I said at the beginning, it is your burden as the employer to maintain documents and to be able to prove that the employee worked certain hours and that the employee was compensated for those hours. Okay, so you need to have timesheets or some form of time cards, timesheets, some form of timekeeping record. Okay, that record needs to be accurate. It must show when the employee starts working and when the employee stops working, when the employee takes a lunch period and when the employee comes back from a lunch period. It's very important that it be accurate, and also that obviously that it shows that the employee took a compliant meal period, meaning before the end of the 5th hour of work, unless the employee has a 6-hour waiver. And also that it took a second meal period if the employee works between 10 and 12 hours in a day. Now, the wage statements are also very important because that's the only way that you can show how much the employee was compensated. Okay. Now, Section 226 of the Labor Code has very specific requirements as to what needs to be included in the pay stub, the wage statement. As you can see here, it requires that the gross wages be indicated on the pay stub, the total hours of work for each type of work, meaning total regular hours, total overtime hours, premium pay, all deductions, net wages, the payroll period. Very often I see pay stubs that have the beginning or the end payroll period, but they don't have both. It must state both when the payroll period begins and when the payroll period ends. Of course, it has to show the date that the employee got paid. It has to have the legal name of the employee and the last 4 digits of the Social Security number only, unless the employer has an employee ID number. It has to show the name and address of the employer, and that means the legal name of the employer, not the DBA, not how people in the community know the employer, but the actual legal name that is filed with the Secretary of State. Very important that that is on the pay stub. And of course, it has to show all the hourly rates and all the hours worked for each rate. So it should show regular hours, the rate, the regular rate, number of hours worked, overtime, the rate, and how many overtime hours were worked. If you pay your employee any premium pay for, let's say, not having taken a compliant meal period, that should also be indicated on the payroll stub, either as premium pay or penalty or miscellaneous, whatever you want to call it. If you pay a split shift, the payroll stub should indicate that a split shift was paid. Okay. Missing any one of these requirements under Section 226 carries penalties. The penalties, excuse me, the penalties are $50 for the first payroll period, $100 for any subsequent payroll period, up to a cap of $4,000, and this is per employee. This is one of the penalties that plaintiff's attorneys really like, because if they file a PAGA claim or a class action claim, they can multiply the 4,000 number by the number of employees. And then, even though not specified under Section 226, as many of you know, now we have a California paid sick leave and a local paid sick leave for the city of LA, the county of LA. And there's a requirement that the employer provide a writing to the employee every payroll period, letting them know how much accrued sick leave they have available or how much they have used. So obviously the easiest way to do it is to include it in your payroll stub. Very often I get the question, do we need to include vacation pay on the payroll stub? There's no such requirement, but it's a good idea to include that information on the pay stub so the employee knows how much vacation they have available to take. No, I skipped a slide here, so let me go back and see. I just wanted to emphasize one thing. Under the law, the employer is required to maintain either a copy of the actual payroll stub that was given to the employee or some other document that includes all the information that was given to the employee on the payroll stub. So sometimes a payroll registry may not be sufficient if it doesn't include all that information. Okay, so if you use a payroll company, make sure that you have access to a payroll registry that would have all the detailed information on the payroll stub, not just total hours worked, but the regular hours worked, the overtime hours worked, all those requirements that we saw under Section 226. Because you need to be able to show that the pay stub that you gave to your employee contained all that information. We already covered this. Hourly employees must record accurate start times and end times. Rest periods do not need to be recorded. Any corrections on the timesheet, any corrections at all, should be made or approved by the employee. The employer should never make any corrections on its own. Okay? It's a good idea to have a method or some procedure in place that allows the employee to acknowledge the accuracy of the hours worked on the timesheet, whether it's done on a daily basis or whether it's done at the end of the payroll period. There should be some form where the employee can review their time for the payroll period and approve it, acknowledge that it's accurate. Okay? Off the clock work, we continue to see allegations of people working off the clock. What's important here is for an employer to have a very strong policy, a very strong written policy. Okay? It's not required in the law, but it's the only way that you can show that you have a strong policy against working off the clock. So you should have something in writing that the employee signs, that he acknowledges that the employer does not allow for off-the-clock work. And if anybody in management requests that an employee work off the clock, the employer should report that to management right away. Okay. Rounding. Rounding is still legal in the state of California. Okay. However, rounding is legal only if the end result of the rounding does not benefit the employer but benefits the employee. So what happens very often is that employers would use the practice of rounding, but they never double check to make sure that it's not benefiting the employer more than the employee. And then if that's the case, then the rounding practice is going to be illegal and it's going to subject the employee to liability. Okay. There was a recent case, the Troster case, Troster versus Starbucks, where in that specific case, the California Supreme Court found that this manager was entitled to get paid for that minimal work that he was performing after he clocked out. And the reason is that the court said if the employer requires his employees to work minutes off the clock on a regular basis or as a regular feature of the job, then the employer may not evade the obligation to compensate for that time. In other words, if the employer knows that the employee is working a certain amount of time after they clock out, even if it's minimal, even if it's a few minutes, then the employer should be compensating for that time. Okay, so I include this here to pretty much tell you what my recommendation is to our clients. Don't round and do not allow for any amount of work to be performed off the clock. Okay, nowadays we have great technology that allows us to be able to compensate employees for all the time they're working, including every minute. Okay, the de minimis doctrine that many employers use to defend any work that is being performed after they clock out, really it should only apply to those rare incidents when somebody has to work a few minutes after clocking out, but it's not on a regular basis. Okay, so that we have the ability to compensate employees for all the time that they work, and we should do that. I remember, have a strong written policy against off-the-clock work. Do not round, and if you know your employees are performing any amount of work on a regular basis after they clock out, then you need to find a way to compensate them for that. Another way that we see this is with employees nowadays having access to emails from their home or texting on the phone concerning work. Now, if the reason that we're texting an employee is maybe just to double check, hey, are you available tomorrow to work? We need somebody to cover a shift. I'm not concerned about that. But if the employee is expected to check their text, their phone, their emails, let's say every evening to see if they have to work the next day, then that time should be compensated. If we're requiring our employees to access any email on a regular basis, they should be compensated. So be careful if with employees who access the emails on a regular basis or the text after working hours, because you may have some liability for that work if they can show that you knew it was happening. Not only you knew, but it was expected that they would have to check their email. Reimbursement of expenses. This is very simple. Under Labor Code Section 2802, an employer must reimburse employees for all expenses incurred by the employee in the discharge of their duties. That includes if they use their own car, then you need to reimburse them for the mileage of the use of their car. If they use their cell phone on a regular basis for work, you should be reimbursing them for the cell phone. Now, I know it's difficult because people also use their cell phones for personal reasons, but you can reimburse them a flat fee a month or payroll period, $10, $20, $25, whatever you think is reasonable based on the amount of the cell phone usage. Personal computer, office equipment, anything that you know that the employee is required to use at home, then you should be reimbursing for that use. Uniforms, meals, entertainment, liability, insurance. Going back to mileage reimbursement, there's a presumption that if an employer reimburses the employee at the IRS rate per mile, then there's a presumption that the employee has been properly reimbursed. However, that does not mean that an employee cannot challenge that amount and say, no, maybe this reimburses fully other employees, but it doesn't reimburse me fully for the use of my car. So if you just remember that if the IRS rate is challenged by the employee, then you need to sit down with the employee and see what is an appropriate rate for reimbursement. But just remember that if the employee is using any of their personal property to perform their duties, then you need to reimburse them for that use. Payroll deductions. I'm seeing, again, still many issues concerning payroll deductions. Obviously, an employer can make those deductions required by state and federal law. That's not a problem. Any other deductions must be expressly authorized by the employee in writing. Okay, and that includes deductions for benefit plans, premiums, or anything like that. Obviously, garnishments, that's a court order, so you probably do not need an authorization from the employee. You are not allowed to make deductions for uniforms, for mandatory medical or physical examinations. You should not have a deduction for a balloon payment or an outstanding loan, or you cannot make any deductions for any damage of company property due to negligence. I always caution employers to deduct for any kind of damage caused by the employee. The reason being that the law only allows the employer to make deductions for damage caused by the employee if they can show dishonesty, a willful act, or gross negligence. These are high standards to meet, and the burden is on the employer to show that there was gross negligence. Otherwise, if it's just standard negligence, the law views that damage or that as a cost of doing business for the employer. Okay, so be very careful with any deductions other than the state and federal law requirements or anything that is expressly authorized by the employee in writing. Now, going back to loans, if you make a loan to your employee, you can make deductions from their paycheck. Again, you want to have something in writing, but what the law doesn't allow is if the employee leaves your employment is to collect a balloon payment for the balance of the loan. If you need to do something like that, you may want to have a separate agreement where they agree to make that balance of the loan to you. And anything that is required by the employer cannot be deducted from the employee, like physical examinations, drug testing, or anything like that. Uniforms, if you require them to wear a uniform, you must provide the uniform at your cost. You cannot charge the employer for uniforms. Payroll period, I think I kind of touched upon this briefly. Wages are due and payable twice during each calendar month. I still see some employers that want to pay once a month. That is not allowed for hourly employees. They must pay at least twice during each calendar month. The employer must designate a pay date. The employee must know what that pay date is. Now, you can have a payroll period that is from the 1st through the 15th of the month. In that situation, then you have between the 16th and the 26th to pay the employee. And then the work performed between the 16th and the last day of the month must be paid between the 1st and the 10th of the following month. However, even though you have 10 days to pay, to make the payment for the work performed, it should always be on the same day, either the 5th, the 7th, whatever day you choose, but it should not fluctuate from one day to the other. Okay. Now, if an employer pays its workers on a weekly basis, then payment must be made within 7 days. Now, the law does allow for overtime to be paid on the subsequent payroll period. However, if you have enough days after the payroll period has ended, you should be able to pay the overtime within that same payroll period. Final payrolls. If you're going to terminate somebody, then you have an obligation to pay the employee all the wages due immediately at the time of termination. If an employee resigns without giving the employer 72 hours notice, then the employer has 72 hours to make the final paycheck. If the employee resigns with 72 hours notice, then the employer must have the pay ready when the employee leaves. Final payment should not be mailed unless the employer has authorization from the employee to mail the final paycheck. Now remember that under Section 203 of the Labor Code, if an employee does not receive all their wages due, including accrued vacation, because accrued vacation is considered wages, pursuant to these rules, these final pay rules, then the employee is entitled to an additional day of pay until he gets all the wages paid up to 30 days. It's another penalty that plaintiff's attorneys really like because then they can take 30 days of pay and multiply that for each employee in a class action or a PATA claim. Document retention, you need to keep documents at least 4 years. At the very, very least, 4 years, because if somebody files a wage claim against you, they can go back 4 years, so you need to be able to prove the number of hours worked and the amount of compensation paid. As many of you know, we have several minimum wages. Pretty much an employer in California is going to see a minimum wage increase every year. If you are within the city of LA or within the county of LA that is not an incorporated area, then you're going to see a minimum wage increase every 6 months, one from the state and one from the city or the county. And I've given you there's a difference whether you have 25 or less employees or 26 or more employees, and you can see the different rates that apply on this slide on the California law. And then the next one, you can see the local minimum wage under the city of LA. So, if you're not within the city of LA, you're within a different city, you need to double check with your own city, because there's several cities out there that have their own minimum wage. And generally, the way to look at it is not based on where the employer is located, but is based on where the employee performs the work. So let's say that the employer is based in the city of San Fernando, but the employee works 2 or more hours per week within the city limits of LA or within the county of LA, then that employee is going to be entitled to the higher minimum wage under the city of LA. Again, it also applies to the county of LA unless they are within its own incorporated area. That gives you some information there. Very quickly, because I'm running out of time, some preventative solutions. The only way you can avoid having a PAGA claim or a class action claim is 100% strict compliance with the provisions of the labor code. It's the only way. So you need to avoid technical violations, otherwise you can be subjected to statutory and civil penalties. The way to do that is, first of all, understand your wage order. I have talked to so many people that when I ask them what's the applicable wage order, they ask me what is the wage order. There's a wage order that applies to every employer. Either it's going to be an industry one or a specific job one. So you need to determine which wage order applies to you. Sometimes there's more than one wage order that applies to a specific employer. And then you need to follow the provisions of that wage order, which is pretty much what we have discussed today. Another way that you can prevent being subjected to a class action or a PAGA claim is to conduct regular audits, internal audits, to make sure that you are 100% compliant with the law, and if you're not, that you take steps to correct those technical violations. So follow record-keeping requirements, review your payroll practices, train your supervisors to do regular audits on a weekly or a biweekly basis. Make sure that you enforce your meal and rest periods policies. Again, 100% compliance. And then if there's employees who are not complying with your rules, then counsel them. Use your counseling ability to make sure that they comply with you, and of course, consult with legal counsel if necessary. So that's the end of the presentation. Thank you so much for joining us.
Roxana, we do have lots of questions for you. And it was about a dozen. I don't think we can get through them all, but just so everyone knows, we will answer all the questions after the fact that we don't get to. So let me just start, if that's okay with you, Roxana. First of all, question is it mandatory to have a policy for makeup time? A written policy.
Not, okay. That's easy. It's not mandatory to have a written policy. It's a good idea to have a written policy, but you definitely need to have a form that the employee signs every time they want to make up the time.
Okay, very good. Question. If every employee works for 8 hours a day and we cannot have all of them leave at the same time, some of us take it until 2:30 p.m. Would that be an issue? Take a break, I'm assuming that's what was referred to there.
So I'm assuming that they're taking the lunch period at 2:30 and it's past the 5th hour. That will be a problem. I'm not sure what that question means. So whoever sent that question, go ahead and send me an email. I'll be glad to give you a better answer.
Yeah, I have the person's name, and I'll forward that on to you. Okay, next question coming up. Then, what if the employees are required to answer a call, such as a domestic violence call, but they could be at home and not close to the work premises? This would be in the context of on-call time, I'm assuming.
Right, and then that means if that person can go about his or her business without having to stay at the house, and they can live their own, the life then that's uncontrolled standby, does not need to be compensated. If the person is required to stay at home and they cannot leave, then that is controlled and they should be paid.
Okay. What is the best way to inform employees that there will be a change in payroll cycle going from weekly payroll to bi-monthly payroll?
The best way is just to do a memo and let them know and give them some time to be able to adjust their finances. I usually say, at least 30 days is sufficient. There's no requirement under the law, but I think 30 days is sufficient to let them know that the payroll cycle is going to change.
Okay. I can answer this one. People want to access the PowerPoint webinar, and yes, it'll be posted on our website for all. Or you can send me a note and I will give you a link where you can download the PowerPoint in the webinar. Next question. Does our law firm, whoops, it just jumped, hold on. Does our law group, have an approved on-duty meal period agreement per slide number 18?
Yes, we do have an on-duty meal agreement form.
Okay. Is split fee or, whoops, these keep moving. Is split fee or percentage commission allowed in California?
A split shift. One more time, can you read that again, please?
It says, is a split fee or percentage commission allowed in California?
That's not very clear. Yeah, and the short answer to that is yes, if I understand the question correctly. Yes, it is allowed. One thing to remember about commissions agreements, under California law, commission agreements must be in writing.
Okay. Let's see. If an employer has 50 employees in different localities and just 10 in the city of LA, which minimum wage does apply? The one with 26 or more employees or the one with less?
That's a good question, and I believe there is a radius that that is used to determine the number of employees, and I do not remember what that is right now. But again, I'll be glad to provide that information if you send me that question.
Okay. If employees work 6 hours or less, can they choose not to take a meal period? And should we have a waiver?
Yes, the answer is yes. If an employee works no more than 6 hours, they can sign a waiver waiving their meal period, and you need to have it in writing in order to show that it was the employee, that the employee agrees with the waiver.
Okay. Can an employer ask for a uniform deposit and return the deposit when the employee quits?
Yes, the short answer is yes, but I do not recommend that. The law requires that the funds be deposited in a special account and that the employee receive also all the interest. So it's not a good idea. It's a very complicated process to ask for a deposit for uniforms.
Okay. This is flipping the coin. Are exempt employees required to complete a timesheet as well as for record purposes?
No, an exempt employee is a salary employee. The idea of a salary employee is that they will work, that they will complete a job or a specific duty regardless of the numbers of hours they work. So salary employees are not required to complete a timesheet because they're going to get paid regardless of how many hours they work. Now, if an employer wants to have them maintain a timesheet, that is okay. Nothing says that you cannot, but it's not really required.
Okay. Let's see. Reimbursements to employees, should these not be together with the payroll check? Is that correct?
They can be. It can be either or. It can be included with the payroll stuff as long as it identifies on the payroll stuff the reimbursement. I think it's a better way is to have a separate check for the reimbursement.
Okay. And we'll do one final question here. What if an employee abandons their job? How does the employer send the final payment if they're unable to get the employee approval or reach them or contact them?
Yeah, and that happens often. I would send them something in writing, an email or a letter saying, first of all, making having proof that the person abandoned the job. You have not shown up to work in so many days. We're assuming that you have abandoned your job. We have your payroll, your final payroll check here. Please let us know when you can come to pick it up, or let us know if we can mail it to you. I will have first something in writing that shows that you contacted the employee and you told them that the check was ready. Then I will just keep the check there. Eventually, if you want to mail it, I guess you can mail it, but the law doesn't allow for that. You're supposed to just keep the check at your office, at the place of employment, and wait for the employee to pick it up, unless they call you and they say, go ahead and mail me the check.
Okay. At this point, I think we need to close it out, but I sure do want to thank everybody who attended and all of those of you who put in questions for us, and be advised, be aware, and assured that all of the questions will be answered. And you can also send others that you think of throughout the day based upon this to either Roxana or myself, and we'll follow up with you. So with that, once again, thank you all, and we look forward to seeing you all at our next webinar and our workshop coming up next month. Thank you.
Thank you.